So welcome everyone to this family law presentation on extreme risk protection orders. We are glad to have Evan Brannigan, Boulder County attorney, here to present on this very important topic. If you have any further questions, you can send them to me. My information will be in the description of this CLE and also in the video recording. And I can make sure to get those to Evan and try to get an answer for you. But without further ado, Evan Brannigan.
Thank you, Kyle. Thank you, everyone, for attending. All right. Here we go. So this presentation is about three things. It's about ERPOs, it's about ethics, and it's about the man from the 16th century, Gerardus Mercator. Main focus today is going to be about extreme risk protection orders. These are commonly known as sort of the red flag law, and it's a relatively new law. It was enacted, it went into effect January 1, 2020. So as of this recording here, we are in October 2021. So it's been about 22 months. What is an extreme risk protection order? It's a legal tool that's designed to save lives from violence from firearms. And there's sort of two use cases here. It's for cases where violence is contemplated to self and to others. And I want to start by talking about violence to oneself, suicide. I'm going to start by giving a background about suicide in our state because I've learned quite a bit about suicide. So in 2020, there were 1,294 suicides in Colorado. And to break that down by gender, and the numbers by themselves are sort of hard to conceptualize. So I broke this down into 4 slides. And each of these people on this slide here represents a suicide death by a male in Colorado in 2020. And so this slide here has 280. And this slide has another 280 males. This third slide has another 280. And this last slide here has 179. And so in 2020, there were 1,019 men who killed themselves in Colorado and 275 women. Of those numbers, about 205 at least were military veterans. And I want to say a little bit about circumstances. And these statistics are from the State Department of Public Health. Of those suicides, about 35.8% of them had a crisis within 2 weeks prior to their death, some sort of acute crisis. And these are statistics from 2004 to 2019. Again, Colorado suicides, almost 29% people who committed suicide had an significant alcohol issue. About 19% had an issue with a non-alcohol drug or substance. At the time of death, about 35% of Coloradans who commit suicide have alcohol present in their system. So about a third. And about a third Coloradans who commit suicide disclosed their suicidal intent to someone, a colleague, a friend, a family member. About 1 in 3 tell someone before they're going to commit suicide. In about 19 cases, there was a significant argument right before someone committed suicide. It could be a family, a work, an argument with a friend, something like that. Almost 1 in 5. Coloradans who committed suicide, almost 19% had a contributing financial problem at the time of suicide. Bankruptcy, debt, divorce. About 16% had a contributing criminal legal problem. Charged with a crime, committed a crime, concerned about that. Of Coloradans who committed suicide, almost 10% had the death of a friend or family member, not by suicide. So that is a significant risk factor. About 7% had a contributing civil legal problem, something like a bankruptcy or a divorce. Suicide impacts Coloradans across all ages, right, as young as 10. And in general, older Americans have the highest incidence of suicide. It's about 30.4 per 1,000 Coloradans who are 75 or older. But as you can see here from this chart, it's a problem across the board, really. This is an important slide about what's happening in the last 20 years, and that is that our suicide rate in Colorado has consistently gone up. So between 2003 and now, 2020 is about a 30% increase in the rate of suicide. All right, I want to talk about something called case fatality with suicide. And this number, 8.5%, is approximately the rate that a suicide results in a fatality. And so the takeaway here is that most suicide attempts are not fatal. And in fact, most people who survive a suicide attempt go on to die from other non-suicide reasons, and that's about 90%. So about 91.5% survive a suicide attempt. About 90% of those go on to die by another non-suicide means. ERPOs are about firearms, and firearm suicides are different. The case fatality rate for a firearm suicide is approximately 90%, and it might even be higher. So if you have access to a gun and you plan to commit suicide, you're about 9 times more likely to not get a second chance at life and survive that attempt. And of the 1,200 or so suicides in Colorado, in 2019, there were 638 suicides by firearm in Colorado. So for some context, that's about every 13 hours, Colorado, someone commits suicide by firearm. All right, so let's talk about ERPOs. This is the bill that enacted ERPOs. Again, it went into effect January 1, 2020. I want to talk about 3 issues. I want to sort of teach kind of the basics about ERPOs. I want to talk about 3 things. I want to teach you about the legal standard for an ERPO. Number 1, I also want to give you a general overview of how an ERPO works. And number 3, I want to talk about who can file an ERPO. So here we go. What is the legal standard for an ERPO? And I'm going to represent this using sort of a Venn diagram. And this circle here represents firearm owners in Colorado, a lot of people. ERPOs are concerned with this group within this circle. And what's different about firearm owners in this circle is they meet the legal standard. So the legal standard is that the respondent poses a significant risk of causing personal injury to self or others in the near future by having in his or her custody or control a firearm, or by purchasing, possessing, or receiving a firearm. That is the legal standard for an ERPA. One quick aside here, ERPOs are in about some version of an ERPO law is in effect in about 20 other states, more being added year by year. They're all a little bit different, and I am just talking about Colorado's ERPO law. Other states have different names. So for example, in California, they're called gun violence restraining orders. All right, number 2. How does an ERPO work? So every ERPO has a petitioner and a respondent. And I want to set the stage here by saying that an ERPO is, in a lot of ways, it's modeled after our temporary protection order and civil protection order statute. So it's a civil matter, it's not criminal. There's one petitioner or multiple petitioners, and there's one respondent. And how it works is the petitioner fills out a form, petition, files it in a courthouse. Where can it be filed? An ERPO can only be filed in the county that the respondent resides in. So I'll come back to that because that's caused a bit of confusion, but the place that an ERPO can be filed, one place only, and that is in the court, in the county where the respondent resides. Every judicial district is different. In many judicial districts, they can be heard by either county court judges or district court judges. That's the case here in the 20th in Boulder, but every judicial district is different. In some places, it's just in county court. Some places it's in district court. If you're representing someone, a prospective petitioner, you need to find out where the respondent resides. And then you need to find out in that jurisdiction, is it a county court? Is it a district court? Where can you file an ERPO? Depends on the judicial district. But an ERPO is filed, and then there are basically 2 outcomes. Pretty straightforward. Is judge is going to review the ERPO, determine if it meets the legal standard, and if the judge decides that the respondent does meet the legal standard, that the respondent is a significant risk of causing personal injury to themselves or others, then the judge can grant an ERPO. And that is an order that will temporarily remove firearms from the respondent. So a note about timing. There are, just like there's a TPO for temporary protection orders and then a PPO making them permanent, there is a temporary ERPO or a TERPO, which lasts up to 14 days. And that hearing is ex parte. The TERPO lasts for 14 days and then goes to an ERPO hearing. An ERPO hearing or an ERPO order lasts a maximum of 364 days. So about a year. So it is a temporary measure to remove firearms. And if a court grants an ERPO or a TERPO, they grant an order that law enforcement then goes and temporarily removes firearms. Now, if the judge looks at the petition, here's the evidence, and determines that the respondent is not a significant risk of causing personal injury to themselves or others by having custody or control of a firearm, judge won't grant the ERPO or the TERPO, and the respondent retains their firearm. So there it is, basically 2 outcomes. All right, number 3. Who can file an ERPO? There are two types of people who have the ability to file an ERPO or a TERPO in Colorado. So I'm representing those using a heptagon here, number one, and then a badge. So the two groups of people are, number one is a family or household member of the respondent can file an ERPO. Got to be a family or household member. Number two, second type of petitioner for an ERPO is a law enforcement officer or agency can file an ERPO or a TERPO against anyone in Colorado. Don't have to be related. So those are the two types of petitioners. Those are the two groups that can file an ERPO. So that obviously raises the question, who is a household member of, or family or household member of the respondent? And that is why I represented this using a heptagon, because there's 7 types in the statute. There's 7 types of family or household member relationships. And here they are. So person related by blood, marriage, or adoption to the respondent, a person who has a child in common, regardless of whether they're married or living together, a person who regularly resides or regularly resided with the respondent within the last 6 months. So this would include a roommate, for example. Number 4, a domestic partner of the respondent. Number 5, persons who have a biological or legal parent-child relationship. So that includes step-parents, stepchildren, grandparents, and grandchildren. Number 6 is legal guardians of a respondent, or someone who's previously acted as a legal guardian. And 7 refers to 186800.3, the criminal code, and that really adds sort of two new types, and that's former spouses and past or present unmarried couples. So those are the 7 types of family or household members who can file an ERPO in Colorado. All right. Any questions so far about ERPOs? Before I move on to ethics. All right, ethics. I'm going to talk about the rules of professional conduct. And I'm going to focus on a couple specific rules. And I have this highlighted here, the preamble. The very first sentence of the preamble to the rules of professional conduct emphasizes that lawyers have a special responsibility for the quality of justice. So, talk about 3 rules from the rules of professional conduct. I'm talking about the lawyer as an advisor, what that means, what our role is. I'm going to talk about the rule that involves communication with represented persons, and why that's important to know if you are doing ERPO litigation. Also going to talk about the rule that involves candor to the tribunal, because that is something that will come up, I think, often in these kinds of cases. This is Rule 2.1. What do lawyers do? We're advisors. Lawyer is an advisor. Rule 2.1 says that in rendering advice, a lawyer may refer not only to law, but to other considerations, such as moral, economic, social, and political factors that may be relevant to the client's situation. Rule goes on to say that a lawyer should advise the client of alternative forms of dispute resolution that might reasonably be pursued to attempt to resolve the legal dispute or to reach the legal objective sought. And this is important. One sort of mental model analogy to think about is that if you're concerned about your friend, you might be out at the bar and you're concerned that your friend might be inclined to drive their car when they're inebriated. You're not necessarily going to run to the courthouse and ask a judge to enter an order temporarily suspending their driver's license. But you might take their keys away. And in the context of firearm violence, you might take their guns away. You might work with them to talk about their state being sort of a temporary state, because that is a common thing from the statistics I cited at the top of the presentation, is that a lot of times suicide is a relatively impulsive decision. A lot of times it's in response to some sort of human event that is temporary and fleeting. So a criminal problem might be very, very scary. Might be really hard to see yourself getting through that. A divorce might be very scary. Might be very sad. It's often a very difficult thing to get through, but people get through it. And the point here is that there are non-legal tools to address this kind of situation. And so this is a tool I want to tell you about. It's called Lock to Live, which is sort of a cool little web app, which helps people temporarily reduce access to dangerous things like firearms. There are a lot of voluntary options. You can lock your gun up in a safe. You can use other sort of locking devices. You can give your gun to a licensed firearm dealer. You can often turn your firearm temporarily in to law enforcement if you're concerned. You can talk to your family member, your friend, whoever's going through this kind of crisis, and this is a great tool to help, short of going to court and filing an ERPO. Back to Rule 2.1 here, lawyer as advisor. Matters that go beyond strictly legal questions may also be in the domain of another profession. And I have found in my research, talking to people, that's especially true in these cases. Family matters can involve problems with psychiatry, clinical psychology, or social work. And the rule reminds us that when consultation with a professional in another field is something to recommend, the lawyer should make that recommendation. So this is Colorado Crisis Services. It's a 24/7 hotline. Here's the number, here's the website. It is free. One thing I learned is that crisis hotlines, suicide hotlines that I didn't know going in this, but I want to share with you, is that these resources are available not just to people who are themselves in crisis. You don't have to be suicidal to call a crisis hotline center. They also are trained professionals who are trained to serve those adjacent to crisis. So if you are concerned about a family member, a friend, a roommate, a colleague, you can call Colorado Crisis Services. It's free, it's 24/7. Here's the number. Lawyers who are dealing with these issues should have this information, because a lot of these issues involve acute crises that are sort of beyond our training. All right. Second rule here I want to talk about is, communications with persons represented by counsel. And so this is Rule 4.2. It's a good rule to know. And here's why it's especially important for ERPOs. Again, the rule says that a lawyer shall not communicate about subject of representation with a person the lawyer knows to be represented by another lawyer in the matter unless the lawyer has the consent of the other lawyer or is authorized to do so by law or a court order. All right, so what's special about ERPOs? In every ERPO case, the respondent automatically, upon the filing of the case, gets appointed an attorney. This is true in every single case. Unlike in criminal law, there's no means testing for this. You don't need to qualify for an attorney. The statute is plain that upon the filing of a petition, the respondent is appointed an attorney immediately. So if you are representing a petitioner, and you have filed a petition, the other party is represented, and you may not communicate with the other party without the consent of that appointed attorney. Very important. Okay, third rule here, I want to talk about candor to the tribunal. This is in the Rules of Professional Conduct, Rule 3.3. And this is important because TERPOs, I mentioned TERPOs, the temporary extreme risk protection orders, like the equivalent TPO, a TERPO is ex parte. So the TERPOs are heard without notice to the respondent doesn't know, the respondent isn't present. These are ex parte hearings. You need to be familiar with RPC 3.3. So RPC 3.3, in an ex parte proceeding, the lawyer shall inform the tribunal of all material facts known to the lawyer that will enable the tribunal to make an informed decision, whether or not the facts are adverse. If you are litigating a TERPO, you've got to know this rule. You've got to think through in advance. You've got to know, first, what are the material facts that will enable the tribunal to make an informed decision? That's one analysis, one level. And second, whether they're adverse or not. So obviously you're going to present the facts that are not adverse, that support your client's ERPO case. But you've got to be aware that if there are adverse facts, there are extra things, because the respondent is not represented, you have an ethical duty in an ex parte proceeding, in a TERPO hearing, to inform the judge of all material facts, whether they are adverse or not. Right. You have any questions so far? Any questions about the ethical rules or the legal standard? I will hold for a moment. All right. I want to talk about Gerardus Mercator. He was born in 1512, and he was a Flemish cartographer, a map maker. And as part of the presentation, I want to talk about what Gerardus Mercator can teach us lawyers about our work. This is what Gerardus Mercator is famous for. It's called a Mercator Projection, and it is a spherical map. 1569, he came out with this. And what was unique and really revolutionary about the Mercator Projection, the Mercator map, is he was able to plot latitude and longitude lines on a spherical surface. And what that did is it allowed sailors to navigate around the world. What was revolutionary about it, it was designed specifically to help sailors navigate long distances across the Atlantic Ocean. A lot of sailors who died before this map. A lot of sailing was done in relative proximity to a landmass. You sort of go up and down the coast and see where it goes. But it was a big problem to navigate across the Atlantic, many weeks, months. The tools, the maps were not set out to help sailors navigate around the globe. And that is what is revolutionary about the Mercator projection and the Mercator map. I want to go back to the preamble, to the rules of professional conduct. The preamble sets out that lawyers perform various functions, and the preamble sets out 4 specific functions that a lawyer does. Lawyer's an advisor, a lawyer's an advocate, lawyer is a negotiator, and a lawyer is an evaluator. These are the 4 things that lawyers do. So I want to focus on number 1 and number 4 for a moment here. Lawyer as an evaluator and lawyer as an advisor. So what does a lawyer do as an advisor? The preamble says that as an advisor, a lawyer provides a client with an informed understanding of the client's legal rights and obligations and explains their practical implications. Right? As an advisor, a lawyer gives a client an informed understanding of their options. And as an evaluator, a lawyer acts by examining a client's legal affairs and reporting about them to the client or the others. So a lawyer is going to investigate facts. Once they investigate facts, they're going to advise the client with an informed understanding of their legal options. So the question is our legal system designed to help ERPO petitioners navigate the legal system? So let's take a look. This is 1314.5-101. This is the statute that describes ERPOs, the procedure, the process, subject matter, jurisdiction, etc. This law is 26 pages and it looks like this. You might Google extreme risk protection order and you might end up here at the State Judicial Branch website. This is a section for extreme risk protection orders. And the state website tells you that these instructions are for informational purposes and do not constitute legal advice about your case. Here they are. There are 14, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. There are 14 different JDF forms about ERPOs that if you are a potential ERPO petitioner, you've got to figure out, how do I file an ERPO? Which one of these forms do I use? And you might click right here on these instructions, JDF 572. I think every lawyer in Colorado knows what these kinds of instructions look like. And this is what they look like. You got a bunch of all caps. You got a bunch of words everywhere. You got a bunch of check boxes. You get this nice scary disclaimer here at the top that if you choose to represent yourself, you're bound by the same rules and procedures as an attorney. And you've got to figure out how to deal with these. Now, I think this is a particular problem in the ERPO scenario, because if you are a potential ERPO petitioner, what that means is that you're concerned that one of your family or household members is a risk. It's putting someone's life at risk, right? This is not, a routine business dispute where you might have time to think it through and go talk to 2 or 3 other business lawyers and come to a rational decision about which one to hire and what course of action to take. If you're considering filing an ERPO, you are in an emergency situation. Someone's life is at stake, and you've got to navigate this law, these forms, and these instructions. So I want to take a look a little bit at some of the statistics that we know of. And there was a paper out by some researchers here at Anschutz that just came out this week or last week that took a look at all the ERPO filings in 2020. So remember, over 600 firearm suicides in Colorado in 2020. Total number of ERPO filings, about 100. These numbers are a little bit fuzzy here because some of them, the researchers didn't have enough information to sort of categorize and qualify them. They were able to analyze about 86, but there were about 100 ERPOs that were filed. So about 1/6 the number of firearm suicides in Colorado. Of these 86 that these researchers looked at, about 34 were filed by household or family members, first kind of petition. And about 52 were filed by law enforcement. Law enforcement petitions were granted at a much higher rate than family or household members. And of those 34 household or family member petitions, 11 were denied for clerical reasons. Some kind of clerical reason. Didn't fill it out right. 3 were denied for being filed in the wrong county, right? Obviously, a judge doesn't have any discretion over that. If you're a judge sitting in Boulder, someone files an ERPO or a respondent that lives in Denver, court in Boulder has no jurisdiction over that, none. Court has to deny it. That happened 3 times. So what can Gerardus Mercator teach us about our work? I think we need to make better maps. I wrote down a couple of ideas here for lawyers who are representing people. And this applies not just to ERPOs, but really to all legal matters. What we're doing as lawyers is we're investigating facts and we are making recommendations about what a client's legal options are. And I'm thinking of those in my work now, not in the sense of evaluating and analyzing and writing a memo or writing an email or calling a client. But I'm starting to think about in my work, my job is to really make literally a map for a client. Because when you think about your work and advising and evaluating in terms of a concrete thing that you produce, it opens up some new ideas that are more accessible to lawyers with technology. Right? And so one of them is we want our maps to be accessible. We want them to be readable. Right? Before the Mercator Projection, there were men who set out on ships, and because of navigation errors, they died. Their maps were not designed so that sailors could plot a straight line course using latitude and longitude. And I think we have a parallel with our legal system. Because when you're in a crisis and you have to sort out this law by using one of these 14 JDF forms that looks like this, has a bunch of scary language on it, well, your petition might be denied for clerical reasons or because you filed it in the wrong county. The other advantage of thinking about our work as evaluating, advising, for me at least, when I think about my work in concrete terms of creating a map, is that a map can be available to a client 24/7, right? You might have a phone conversation with a client on a Wednesday, and I think we've all had the experience that a lot of times clients don't retain all the pertinent, relevant information that you want them to. And that's particularly true, in my experience, in cases where there is an emotional charge, where there is an excitement, there is a danger, there is a serious situation going on. In those cases where someone's life is at stake, which is true in every ERPO case, every lawful ERPO case, people are not at their best. You're just not at your best in terms of how you comprehend information, how you analyze information, how you sort through what your options are and what you should do. So one advantage of thinking about our work in terms of making a map is that we can make a map that's available for a client after we hang up the phone with them. Right? They can look at what we produce that night, the next day, the following week. And if we do a good job and we make a map that's designed to help people navigate their legal problem, then that can be a much more effective way to practice law, right? Our maps can be detailed. We can make them very specific. We can include a lot of information, right? And we can sequence that information when it's appropriate. We can have, for example, information about Lock to Live. We can put the website right in our map and talk to our clients about some of the non-legal options they have to potentially resolve their acute legal situation, right? We can have numbers for mental health services like Boulder Mental Health Partners, which has offices in Boulder, in Longmont, in Lafayette. They have an innovative zero suicide plan. Their goal in Boulder County is 0 suicides. That's a number that we should make available to our clients. The other advantage of thinking about our legal advice as sort of a product is maps. The kind of maps that Gerardus Mercator made were static and fixed, right? And the latitude and longitude bearings don't change a whole lot. And, Europe isn't, Europe and North America aren't exactly moving or shifting, right? Map from the Mercator era is probably pretty similar to how the world is reflected now, or at least it doesn't change as much. But in legal situations, the course of what you might recommend as a lawyer can change in an instant, right? We've all had, I think, that client or that situation where you might be talking with someone for weeks or months or years and sort of giving them advice. And you see the issue one way and then something changes, right? There's one event, there's one argument, there's, in the case of divorce, there's an arrest, there's an allegation, there is something that can happen that can really dramatically change the advice that you want to give that client. And we don't need to think of our maps as static and fixed. They can be dynamic, right? They can change. We can build in And if you think about a map as a computer program, right, or something that has programmability, something that can change, where clients can click on this scenario and, see what happens if this happens. You can provide this kind of map, this kind of program to a client that can be a lot more useful than a fixed, static email or phone call. And particularly with ERPO cases, where things can change after hours, at night, in an instant, right, on the weekend. It might be that on a Friday morning you talk to a client and there is no basis, no legitimate basis to file an ERPO. You might have to tell the client that there's just no way, you cannot meet this burden of proof, you can't file it. And then you go home at 5 o'clock and your client gets into an argument or learns something new from their household or family member at dinner or after dinner or at 2 in the morning. Now, one event might really change your advice, but you aren't available because you're asleep or you're out of town, you're on vacation, right? We can build maps that are interactive. We can build maps where we can help guide clients through possible situations. We can empower them to use our maps when we're not available. Sort of a new frontier of practicing law that I'm excited about. Because it's really easy to think about our legal advice in terms of discrete time periods where I sit down and I write a memo to a client, or I sit down and I make a phone call to a client and I write that down and I bill it. And that's a discrete thing, because that's just not how the world always works. And I think you can do a better job if you can explore these options with clients, something like a digital map, something like a computer program that helps clients on their own explore scenarios as the facts on the ground change. All right. That's what I have. ERPO's ethics and Gerardus Mercator. I don't know if there are any participants who have any questions, but this is my contact information. If you want to email me, evan@better.law. I welcome any advice, any feedback. Do you like this CLE? How could it be better? Please let me know. I'd be happy to hear from you. And with that, I will take any questions if there are any.
And Evan, it's Kyle. Everyone can unmute themselves if they'd like, and they may not have any questions. You may have covered everything so perfectly that there's no need for it. But if you don't mind, if anyone viewing this or later viewing the recording has questions, I can send them your way.
Absolutely. Please,
Perfect.
Evan@better.law.
Yep, Gabriella said, very informative and well presented. Thank you, Evan. So there you go.
Right. Well,
Thank you, everyone. I think with that, I think we can sign off. I thank you for presenting today.
Thank you very much, Kyle. Appreciate it.
Of course. Thank you, everyone. We'll all be in touch. Have a great day.
All right.
Bye.
Bye.